This is the American Law Journal.
You go to trademark your good, your product, your service, and the Patent and Trademark Office says no. How far will the First Amendment go in protecting your interest? This week on the American Law Journal, two cases before the U.S. Supreme Court. One slanted in the direction of trademark, the other dressed up for copyright protection. Both will tell us a lot about the bounds of commercial free speech. Gina Passarella has this.
Sorry if I know it's too sharp. Sorry if our voice is too raw. Don't make the pen a weapon and censor our intelligence until it costs me nothing at all.
How did the Slants
Sorry if you take offense.
wind up on the steps of the Supreme Court? Because the government denied a trademark for their name under a law known as the Lanham Act.
It allows the Patent and Trademark Office to prevent registration of immoral, scandalous, disparaging marks, and it also has provisions for marks that might deceive the public. And in this particular case, they made the judgment that the Slants, the name of a particular band, was disparaging of Asian people.
But for Simon Tam, bass player and spokesperson for the Slants, it's always been about reappropriation, taking a slur about Asian Americans and reclaiming it as their own with cultural pride.
Whenever you Googled slant or slants, the top hits all on Google for the first 4 pages were all to white supremacist websites. And now it's to a rock and roll band that proudly shares its heritage, and I think that is super cool.
And now it's up to the nation's highest court. And although the Slants case looks promising, there are no guarantees. The government wants to prevent registration of the most vile racial epithets and messages, and to disassociate itself from speech it finds odious. Case in point, the intellectual property highway is littered with thousands of so-called disparaging names denied trademark protection.
That's one of the arguments of the Trademark Office, is that we're not preventing you from using the Slants or Redskins. You can still do that. You just can't register it with the United States Patent and Trademark Office.
But getting a registered trademark is a highly valuable business asset. A notion often lost on young members of Ballard Spahr law firm provides a cautionary tale from his early days with the band.
In rural Mississippi, not too many people are trademarking stuff, so it never came up. But I would advise people to think about it early on, because by the time we really got down to dealing with it, we had already started selling records and money was coming in and nobody knew what to do about it. We had some imagery that was the B-girl, for example. It was popular and somebody was making money off of it. We had not trademarked that image or the name from what I understand, until later.
The Slants now hope their betting everything on the First Amendment argument will get them their trademark. And they aren't the only ones betting on the outcome. The Washington Redskins, whose canceled trademark is tied up in the courts, believe their rights will be restored if the Slants prevail.
So I think these are old provisions of the Lanham Act that are archaic, out of date, and should be thrown out completely.
If the government truly cared about fighting racist messages, they would have canceled the registrations for numerous white supremacist groups before they even approached our case.
By granting the Slants a forum, the U.S. Supreme Court is putting the First Amendment and the U.S. government's right to restrict trademarks in the spotlight, raising the question of whether the government is up to the task of deciding what is disparaging or immoral. For the American Law Journal, I'm Gina Passarella.
All right, 4 guests with me tonight, all intellectual property attorneys. Lynn Razonka is the practice leader for Ballard Spahr's Copyrights and Trademarks Group. She's the former managing partner for Ballard's Philadelphia office, and we have at ALJ used her expertise many times in the past with our own copyright questions. Manny Pocattillo hails from Cesar Revis and is recognized as one of the leading intellectual property lawyers in the country. Much of his focus is trade secrets, computer matters, and in the registration of trademarks. John Connell is an employment and civil rights attorney with the Archer Law Firm. He's fresh off representing the Slants before the U.S. Supreme Court. And Ron Coleman is a partner of John's in their Eastern New Jersey, New York City office. His famed IP blog is appropriately named Likelihood of Confusion. So John, Ron, let's go back really to the inception of this case. First off, how did the case get to you? How did you get to meet the Slants?
I met the Slants when their previous attorney concluded that after some back and forth with the PTO on Simon Tam's original registration for the Slants, that he had gone as far as he was prepared to go given his motivation, interest, whatever the case was. I think budget might have been one of those factors as well. He knew that I had written on my blog, on Likelihood of Confusion, about what I perceived as the inconsistencies and doctrinal problems with the application of Section 2A by the PTO.
And how important was it, though, for you to actually sit down with Simon Tam? Once you decided to take this case, how important is that?
Well, we actually never met until the on-bank argument in Washington a little over a year ago. Simon and I got to know each other quite well by
because
telephone.
It seems to me this whole notion of reappropriation, and in other words, to take the name the Slants back, that seems to be a catalyst for taking this case to the Supreme Court, and is got to be part of your case in chief.
It wasn't. It wasn't either, in fact.
Okay. Well, explain that to me.
Well, the first thing we did was abandon the first application, which I call the Chinese menu application. It had all the traditional graphic allusions to Asian identity, dragons, a red color. I said, listen, you are fortunate, unlike those who have tried to use ethnic reappropriation arguments. Slant is a word in the English language. Let's file a new application with no reference to Asian identity whatsoever.
And John, that's why when I think it was Ruth Bader Ginsburg asked you a question, and she said, well, if somebody came along, a white racist came along and wanted to use the N-word in his trademark, you said, doesn't matter.
It does not matter. The intention of the
mark... Did you get a couple of eyes opened at the Supreme Court when you said that?
True, but the fact of the matter is, as a matter of law, the intention of the mark holder does not matter. What matters is the meaning of the mark in context. And context here means its use in commerce, specifically as to Slants, its use in relationship to the service of music. A mark brands the band. People understand the band by understanding the music, and they know the music because they know the band. So the mark unites both together. And in this case, it was important to look at what? The message of the mark by the Slants. That is the political and social message of Asian pride. And that you could discern from the lyrics of the music itself, which the PTO did not look at.
Careful, you're getting back into that reappropriation argument. Ron, maybe.
Well, well, we have to deal with it because the Federal Circuit made it a large part of its opinion. The explicit reference to Mr. Tam as an Asian American, they said the context for offense, the reason we know that you don't mean diagonalness, but you mean Asianness here is because Simon Tam is the applicant. Moreover, the context that John refers to is in itself, at the end of the day, when you have a trademark registration, it recites goods and services. It doesn't say goods and services by an Asian or in reference to Asians. None of these subjective factors, they're not sustainable under the statute, which is just one more reason that the system is quite problematic.
It ultimately ends up also invoking issues of property rights. We saw that with the Redskins trademark case as well. What are the bounds of what the trademark office can give and then possibly take away? Is the line changing based on the vagaries of the trademark statute? Today, when we have such a sea change in terms of what's acceptable or unacceptable publicly.
To give you an example, Doughboy in 1951 was considered scandalous for use on prophylactics. On the other hand, Old Glory was considered to be okay for prophylactics, even though it had the American flag as part of the trademark. It is so changing the terrain that the statute is almost invalid by virtue of it being indefinite, because you can't judge community standards at any one time.
And Ron, we've seen cases recently dealing with First Amendment rights and trademarks. I believe it was the Walker case dealing with the state of Texas. The Sons of the Confederacy wanted to have that on the license plates. It was a very close decision, one of those famous Roberts Court's 5-4 decisions. But in that case, they said the government really can prohibit speech when it comes to trademark.
Well, not necessarily when it comes to trademark, rather, but when it comes to government speech. And that's a gigantic part of this case. We think it's not a part of it at all. But it was one of the hooks on which the government had tried consistently to hang its hat. In Walker, it was a close case because the facts were difficult. And difficult facts often make difficult decisions, as we know. You have to have a license plate. The state decides what the license plate is going to look at. Then they leave open a certain slot, a certain space for self-expression. Essentially, and I don't think the court exactly put it this way, but essentially, the court said the slot that's left open by the state on its mandatory ID for self-expression isn't sufficient to take a license plate out of the category of government speech. Therefore, government does have the ability to regulate what expression is permissible on a license plate.
But certainly that was the argument against you folks and the Slants here saying, look, you can use the name Slants just as much as you want. You can go out and put it on
Actually,
your...
you can't. That's actually a point that we love when people say it, because the beauty of trademark...
But the court said that, though.
Yes, but I'm...
Okay, I understand that you're disagreeing, but the court's basically saying, go out and use the word slants, just don't ask us for a license.
Except, in fact, if you have a trademark registration, you have 50 state priority. You don't have to use your trademark in every territory to have rights in that territory. If our client were to show up in a city or part of the country where he had never performed and find out that someone had started their own band called the Slants, he actually could not use the Slants there. He would not have the trademark rights there, so his speech, in fact, would be reduced compared to others who have registrations and are entitled to presumptive 50-state priority because of the notice aspect of what registration provides for a trademark.
An interesting part of this case, then, that the government's saying is that we're putting our imprimatur on this.
From a practitioner's viewpoint, though, I would disagree. Just because the government and the Trademark Office are granting the registration does not mean that is an endorsement of the underlying mark.
Right, and that's exactly what you argue, John, right?
Yeah, in fact, the Old Glory condom case specifically says that the registration of a mark does not connote any endorsement or imprimatur whatsoever. And in fact, since 1870, when trademark registry first started, how many millions, several million trademarks have been registered? I mean, who among us associates the government with Pepsi or Coke or BMW or Ford or, worse, capitalism sucks donkey balls? All of those are registered trademarks, and yet nobody would ever associate the government with them.
If my history of recent trademark litigation is accurate, the Supreme Court said that 2 Dyke minimum would not be granted trademark registration, and yet Dykes with Bikes gets that registration. How does the layperson understand what can be marked and what cannot be?
Well, an even better example of that would be Dykes on Bikes versus Dykes on Bikes. They got the registration when they first applied for it, not easily, but they are one of the few groups that got a 2A rejection, in other words, rejected on grounds of disparagement, and then successfully made the argument of reappropriation. When they returned to the PTO a few years later, as they explained in their amicus brief, seeking to register further goods and services for the same exact mark, they were rejected on 2A grounds. Something seriously wrong with that system.
And this happens all the time. It happened in the Hebe case as well, because Hebe had registered the mark Hebe for a newspaper about Jewish items, and then they tried to register it for entertainment services, and they were rejected. So it happens. It's been happening since the Madonna case in 1937. They had registered Madonna for a lot of other goods, but for wine, it was considered scandalous. So the fact that the Trademark Office is often inconsistent is just the way it's been happening. That's one of the reasons why the statute should have never been passed in the first place. There really is no business of the government to try to regulate what people use for trademarks.
If I may, when it comes to vagueness, the court in the Harjo case, which had to do with the Redskins, I think this was in 1999, underscored the fact that the statute itself was so highly subjective that it led to inconsistent results. The original Senate report said the same thing. And the fact of the matter is, there are those who say, well, you know, a disparagement is almost like obscenity, you know it when you see it. But yet, if you look at the marks that are registered, there's no rhyme or reason to what is or is not disparaging. It's really almost as if disparagement is in the eye of the examiner.
At one point, so one could argue that the core decisions that the Trademark Office is making with respect to, say, likelihood of confusion could also be argued to be subjective, but there are recognized and accepted tests, multi-factor tests, to make that determination, not the case with respect to disparagement.
Let's segue to hip-hop. How is it that a band such as NWA, N-Word with Attitudes, could get that trademarked And there was a plaintiff, I believe, in that case, or a claimant, who was an African American. Guys, did that come up at all in your research, in your brief? I mean, that would be a tag to something in American culture that the average person could understand.
We did refer to it in the brief, in fact, and we have the credit has to be given to our colleagues at UCLA, Eugene Volokh and Stuart Banner, who were tremendously helpful, to say the least, with respect to that brief. The NWA trademark was used as an example, but I think the simple answer to your question is the word was only hinted at by the initials. It wasn't actually there. On the other hand, when Damon Wayans himself, a black entertainer, tried to register the mark NIGGA, a variant on the N-word.
Yeah.
That was rejected. So that was a line that wasn't going to be crossed. And to a large extent, it seems, my observation has always been, and I've expressed it on the blog many times, that quite understandably, the PTO is above all trying to sort of circle the wagons around the one or two really most offensive trademarks that can be contemplated in a political and social environment where we're rightfully sensitive to the misuse of racial slurs. It's not hard to understand. The problem is it's not constitutional.
Yeah, but you would say a racial slur could be trademarked.
Well, of course
because the First Amendment, I mean, we should honor the First Amendment in this field. That preempts the field.
We must.
And the reason for that is the occasion or even the potential for offense is the reason, the very reason for First Amendment protection.
Sounds arbitrary, doesn't it, Manny? You've been at this a long time.
I mean, have, and it is, and quite frankly, to give you an idea of how arbitrary it is. When the Redskins adopted the mark Redskins back in 1932, they adopted it because of the fact that they had a player they were honoring who was of Indian descent. And then, to make things worse, in 2010, after the mark had become worth hundreds of millions of dollars, the patent office wanted to take back the registration, thereby opening up the mark to having to be proved that it was used in court, that it was valid, that the mark had rights over any other team that had started using the mark Redskins for its team. And believe it or not, there are a lot of high schools that use Redskins in their mascot. So the point is, here is
Atlanta Braves, the Cleveland Indians, et cetera, et cetera, et cetera.
Yeah.
The same
so the
thing.
whole point is, a football team that they wanted to go after, they would have to prove it from scratch because they'd have none of the protections from the Lanham Act.
So, guys, I know you don't own any crystal balls, but we've got to ask you, based on the tenor in the courtroom, I know you're going to say you don't know. What happens here? I know you don't know, but tell me what you're going to let me know anyway.
I'm going to take the fifth.
And you must, and I understand, John. Ron, you have to do the same, right?
John, being the senior and the constitutional expert here, I would not in any way consider departing from his advice.
All right. So, but what
I'll
I
take
can
that
ask,
one.
but I can ask my guest here on the set. So, Lynn, what do you think happens here?
I think it's going down. I think the provision is going down.
Yeah. And because?
Because of the vagaries of the term,
Okay.
the lack of enforceability.
And would you agree with that too?
I
Manny?
agree.
All right. When we come back, we think of copyright dealing with an author's creative work, such as a book, a movie, or song, but a cheerleader's outfit, how that case came before the Supremes could affect your copyright protections in the future. And Paul McCartney is trying to get the rights of his songs back. Does he have a shot? Back in a moment.
This week's American Law Journal is made possible in part by Law Catalyst, video and film production for the legal profession. Go to lawcatalyst.com. King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Blank Rome, providing strategic advice for employers in today's workplace. And The Legal Intelligencer, an American lawyer media publication and the oldest law journal in the United States.
It's known as the fun area of the law, the creative aspect of the law, intellectual property, trademark, copyright, and patents. But even those cases go to the Supreme Court. I'm with four great guests with me tonight. And You know, Lynn, we get it when there's a copyright issue dealing with a book or a movie. But a cheerleader's outfit, why is Star Athletica versus Varsity Brands in front of the Supremes?
Well, it's in front of the Supremes because there has been divergence of opinion among the lower courts about certain aspects of copyright protection. And let me back up and also paint the picture of why this is important to the industry. For ages, the fashion industry has lacked because they have not had copyright protection for fashion designs. This gives them hope that there might be some type of protection. And when we think about the range of intellectual property protection, it does feel like fashion design and apparel design have not had the type of protection that other industries have had. The cases before the Supreme Court, because of an issue involving the scope of copyright protection, particularly with respect to useful articles. So as you said in your introduction, copyright generally protects the things that we think of as quintessentially creative. But what happens when you take that over to a useful article? Should all useful articles have no copyright protection just because they have some use? We have so much merging now of the aesthetic and the useful. So what the courts are struggling with and the industry wants protection for is when you have a useful article that has some type of expressive or artistic elements. Then the question becomes, can you separate those out from the usefulness of the article? Courts have developed generally two types of tests to answer that question. One is the expressive ornamental aspect physically separable? That's easier to answer. But then the harder, more esoteric question is it conceptually separable? We ended up with 10 different type of tests to answer that question. We need some uniformity. Hence, this is the case that the Supreme Court has decided to address the issue.
And Andy, again, we heard the term inextricably entwined in the Slants trademark case, but we're kind of seeing that here with the copyright matter too.
The question is, can you separate the artistic from the utilitarian? And it happens in a lot of cases. There was a belt case years ago that the only reason that the belt was found copyrightable was because of the fact that it was actually being shown in the National Art Museum in New York City. And it was considered to be a real work of art, this belt buckle. So they allowed copyrightability of that well-known work of art. But the reality is it's been a problem throughout copyright law. For example, computer software has always been a question of, can you separate the utilitarian from the expressive? And the problem is you really can't. And when you can't, you really shouldn't grant copyrightability. Yet they passed a statute in 1950 which enabled computers to become copyrightable.
You know, Ron, it's interesting, the parallels between these two cases, again, the Slants case and the Star Athletica case. Again, one a trademark case, one a copyright case, but it seems to me that we're starting to see something that we think of having trademark protection, you know, a statute or a cheerleader's uniform, looking for copyright expression. And even in your case, the Slants case, it looked like you're trying to push the court to say, come on, freedom of expression, First Amendment rights, you give it to copyright, let's push trademark a little bit more into that corner.
Well, I think one thing the cases definitely have in common, and I agree with you, is that in both cases, the statute clearly doesn't provide the answer. There is, in terms of exactly where lines have to be drawn, there is little question that certainly in the Star Athletica case, that the court is being asked to make a policy decision. Congress has certainly had many years, the fashion industry has been banging on its doors for decades, seeking a protection for designs in a way that other expressions of creativity can be protected. And there is another, I don't want to say lobby, but there is another interest group which is very determined to make sure that does not happen. There is an entire industry and not only of what you might call knockoffs, junk perhaps, that is sold at a discount, but of much what you might call better clothing sold in better stores that nonetheless come quite close to the most original designs and that form a very, very important part of the fashion industry. Congress doesn't want to touch it. It's had the opportunity, it knows what the issues are, it's leaving it for the court to make what is essentially a policy decision here. And you know, Star Athletica, one way or another, is not going to be adopted as in whole because the decision itself is a little bit all over the place. I'm sure my colleagues will agree. So ultimately, it seems that the court will almost certainly come up with some kind of test. I would be surprised if the case if the result of Star Athletica is affirmed.
Let's take one last look at trademark copyright tonight. Paul McCartney is trying to get the rights of his songs back, or I guess he's trying to get the copyright rights of some of his songs back. What's happening there, Manny, and does he have a shot?
Yes, he does. This is exactly why the law was written. He gave away the copyrights at a very young age, and under Section 203 and 304, you have a right to terminate the assignment and get the copyright back. And it was specifically made because when authors are young, they don't have any leverage, and they'll sign anything just to get their song published. And now that the song has lasted so long, these songs of the Beatles are just a treasure trove, and they made a fortune for Michael Jackson before he assigned his estate assigned them to Sony.
Yeah.
And now Sony, of course, would like to keep them because they're still making a lot of money. Well, I think Paul McCartney has every right to get it back.
The only issue seems to be whether there's a way to distinguish this case from the previous case that involved the question of whether UK law or United States law applies to the assignments of the copyrights.
Right.
And the argument made very ably by Morrison and Forster, quite unsurprisingly, that it was made ably by them, is that the case was not real. That issue was not really properly argued in the only known precedent involving that intersection. I agree with Manny 100%. This is precisely what the case was meant to, what the statute was meant to represent with respect to termination.
What was the length of time since the cases, the songs were originally released? I think, is it a 36-year period? What is the period?
You have 35 to 40 years.
35 to 40 years.
Yeah, in other words, any time between 35 and 40 years you can terminate and get reversion.
Well, it's not often we get a chance to do trademark and copyright on our program, but I'm glad we weighed in tonight. Again, 2 cases before the U.S. Supreme Court. I want to thank my guest, Lynn Rizonka, stepping up to the plate and joining us for the first time, practice leader for Ballard Spahr's Copyrights and Trademarks Group, Manny Pocatello, partner and name partner, of course, with Cesar Revis. Not name partner, but you're the man with Cesar Revis. For how many years now, Manny?
Only 51.
Only 51 years, recognized as one of the leading intellectual property lawyers in the country. John Connell, who recently represented the Slants and argued that case before the U.S. Supreme Court, and his partner with Archer, Ron Coleman. Again, the man known through his blog, Likelihood of Confusion. For all of us here at ALJ, thank you for joining us this week. Until next Monday night, case closed.
This week's American Law Journal is made possible in part by Law Catalyst, video and film production for the legal profession. Go to lawcatalyst.com. King Spry, serving its Pennsylvania clients in family law, business, personal injury, and school law for over 30 years. Blank Rome, providing strategic advice for employers in today's workplace. And The Legal Intelligencer, an American lawyer media publication and the oldest law journal in the United States.